Yeah.
Good morning, everyone. I'm Chris Parker. This is Kristen Ishihara. We're with the Ishihara Parker Law Firm, and today we are discussing guardianships. Kristen, what is a guardianship? Who are we talking about with the guardianship?
Sure. So, guardianship would be appropriate to consider for an adult that is disabled. So, an adult that is not able to provide for their own financial affairs, or an adult that cannot provide for themselves by providing food, shelter, or clothing.
Okay. And does it also apply to situations where we have minor children who are turning into adults?
Sure. We have, I would say, probably two kind of common scenarios for clients that use guardianships. One is parents of a disabled child that was maybe born with a disability, and that child is now turning 18, but we'll never be able to live independently of the parent. So they're just really kind of continuing, as biological parents past the age of 18. And then another group would be an adult child who has an aging parent who maybe is not making good decisions for themselves. Sometimes that plays out as a parent who maybe has a diagnosis or maybe just, has some age-related infirmities, but isn't going to the doctor, isn't doing the medicine management that they need to, maybe isn't getting all the care that they need. And so the child is worried and needs to step in and protect them for medical decisions or maybe even financial abuse as well.
Okay. And so at its base, when we're talking about a guardianship, we are basically saying, the court is saying, hey, I am removing certain rights, basically constitutional rights of a citizen in our community. Yes, parents don't always see it that way when dealing with their child. Yes, we don't see it that way when we're dealing with our parent. But that is ultimately what we're doing. We are removing rights away from an individual and either placing them in the guardian or the court through the guardian. That is obviously a serious endeavor.
Yeah.
So is that something how does the courts weigh that?
Sure. I mean, it is an adversarial process where you sue that ward, whether it's your child, parent, or whoever, to take away rights. So the state of Texas considers that a very high burden. And so they have put in place measures to really ensure that the guardianship is kind of a last resort. So if there is any lower restrictive alternatives available, the court wants to utilize those. And I bet we could give some examples of what those might be.
Yeah, absolutely. Powers of attorney is our number one option if available. We do them all the time, every time we can. Powers of attorney are very useful documents, especially if you have an 18-year-old older, obviously it'd be age 18 or older, you have an adult who has capacity, and they have a good, reliable family member or network of friends. Maybe you don't need that court involvement. If you can get it done with powers of attorney, that would be the preference. We don't want to take away rights. A power of attorney is a sharing of rights. So that would be a great example of least restrictive.
It would be. I would say that depends a little bit on the agreeableness of the ward. So if your disabled child turning 18 is agreeable and the doctor is explaining they're going to need this surgery and the child is going to do what you say, great. Powers of attorney will probably do the trick. If you have a parent who is unwilling to accept medical care, having you as the agent really probably is not going to help, because with a power of attorney, you are serving at their pleasure. They are still the boss. They are still the adult. They still have the right to make the decision, even if the decision is a bad one. So probably depends on the nature of the situation.
Another situation, we have a disabled child. That disabled child is turning age 18. Well, they don't own anything, right? They've been at mom and dad's. They've been taken care of. The only asset or income they're going to have would be Social Security disability. So we can use that to avoid a guardianship potentially. Is that right?
If the parent applies to be the rep payee for Social Security, and Social Security has a decision-making process that is totally outside of the guardianship. So even if you are the guardian, you are not necessarily the representative payee for the Social Security income that disabled adult is probably receiving. So you will have to go independently, apply through Social Security to be the rep payee, and then they have an annual report that is required for that rep payee. But sometimes you can do powers of attorney and rep payee and not the guardianship, because if the only income or asset that individual has is Social Security, you may get by with that.
Yep, always wonderful. And then one I always find interesting is the use of a trust to help out in these situations. Now, obviously, this is case dependent. A lot depends on whether this trust is already existing, whether they're doing a new trust, what is the the attitude of the person we're wanting to have the trust for the benefit for, but kind of how could you envision that?
Yeah, when I use a trust as kind of a in between, usually I'm doing that because a senior adult is being taken advantage of financially by somebody. Could be a stranger that's coming to their door trying to sell them a new roof, and that senior has the ability to write a $40,000 check out of their checking account, or it could be they've had a child that's always been dependent upon them for financial care that continues to come back, take advantage, or maybe even write themselves checks. So the benefit of a trust there is you can move all of that person's assets into the trust managed by a trustworthy trustee, maybe a good child, a corporate fiduciary, whoever it is. But then all those things are still there for that person's benefit. That person just doesn't have the capacity to make a bad financial decision or be taken advantage of. So that's when I use a trust, that's usually why.
Yep. So some combination of power of attorneys with a trust, sometimes that is sufficient to avoid a guardianship. And ultimately, at the end of the day, we would like to avoid guardianships if we could. We've got great judges here in East Texas, but they have a lot of cases. And there are a lot of cases I think that they would love to have handled outside the courtroom if possible.
Sure. Well, better for the ward, the proposed ward, who gets to retain rights to make decisions. So absolutely.
Let's say I get in one of those situations, Kristen, all those other methods we talked about just aren't going to work, right?
Yeah.
So I know I'm going to need some form of guardianship. What are my flavors? What are we looking at when it comes to guardianships?
Yeah, with guardianships, there are two types of guardianships. One is guardianship of the person, and that's going to allow you to make medical decisions and decide physical residence of the ward. So if I am the guardian of someone's person, I am making decisions kind of like their parent, deciding, what doctor they go to, what medicines they receive, and where they live, essentially.
So guardian of the person is obviously a easier one to handle, a easier one to manage if you were appointed. Less requirements, I suppose, on the yearly requirements and things like that. But what is the other type of guardianship?
Yeah, a guardianship of the estate is going to be when you are taking over management and control of an individual's assets. So that would be more you are applying to be guardian of a aging parent and taking over the assets that they have as guardian.
Okay. So we got guardian of the person, we got guardian of the estate. You could be obviously both, right? You could be guardian of the person and the estate, which is obviously very common. So we've made the decision, we saw you, we talked to you, we've gone through the other methods, they all failed for whatever reason. We're stuck in a situation where we must do a guardianship. What do we do?
Yeah, so the actual process itself is an applicant is going to be the person who applies to be guardian. They will hire their own attorney, and that attorney will help them through the process of applying for guardianship. A guardianship is going to be filed in the county where the ward is residing or can be found on the date of filing. But ideally you want to do it where the ward is probably residing or going to be residing because you do have annual reporting requirements. And so if the ward moves during the year, that guardianship has to be transferred to where the ward is residing. So typically best to do it where the ward is residing.
Okay. So we're going through here. We made our decision. We have decided to move forward with a guardianship. I am going to file an application because I am the applicant. I'm an interested party. I fill it out. I submit it to the court. I'm then going to make sure, or at least the attorney will make sure, that the ward is served with notice application. The court then would appoint a guardian ad litem,
Attorney
ad litem, to represent the proposed ward. So let's talk about this new second attorney who's now showed up. Whose attorney is this, and what is their role?
Sure. The attorney ad litem represents the ward. In the state of Texas, that attorney ad litem has gone through a special guardianship training and holds a certification for having done so. So they do have some specialized knowledge in the field. Sometimes people are concerned, well, mom's going to say she doesn't want a guardian. Well, that's kind of expected, right? Mom's going to say that I've, been stealing her money because that's what she thinks for years, even though I've just been managing it for her. Well, they're, used to having those sorts of things come up, but they do represent the ward. And so that attorney meets with the ward, meets with the applicant, may ask for things like bank records, may talk to a doctor. They're kind of an investigative person and then reports back to the court about what the ward's wishes are because they're serving as that attorney for the ward.
I mean, very, very well, we'll write up a report saying, hey, this is how I feel, and we'll tell the court in open court if you have a hearing.
Right,
Yep.
right. So usually they say whether a guardian is needed and whether the applicant is the right person to serve as guardian. So in a fairly streamlined guardianship process, that's really nothing to be worried about. In a contested guardianship where other people show up to say that not you but they should be appointed as guardian, that job can become a little more important. But
I mean, once there's been a doctor finding that the proposed ward is incapacitated, once you have a letter from a doctor saying that someone's incapacitated and it's filed before the court's going to take action. They're going to protect that proposed ward if it's necessary. Just because you're the applicant become the guardian doesn't necessarily mean you will be the guardian. Is that right?
Right. So the applicant should be prepared for making sure that they're qualified upon filing the application. They would also typically file a doctor's letter or certificate along with the initial application, which would outline what things the ward can do. So it's a statutory provision. What the doctor completes, it has to be a Texas licensed physician done based on an exam that's taken place within 4 months of the filing of that certificate, so that examination is obviously not dated. But the doctor completes, can this person enter into a contract? Yes or no. Can this person make a decision about marriage? Yes or no. The three things that specifically get reported to the state of Texas are whether the doctor says that person can retain the ability to vote, to drive, or to possess a firearm. And typically, in a guardianship proceeding, the doctor will say that no, this person is totally incapacitated and does not have these rights. And then that information is then provided to the state, and that individual loses the ability to do those things. If you had a ward where one of those rights was important to carve out, that would be important to talk to your attorney about.
Okay. So I've got my letter. The attorney has been appointed to represent the proposed ward. They have done their investigation. I have spoken with the attorney I've hired. What happens? What is the general process after we get past that initial filing and appointment of attorney?
Sure. So the applicant or the applicant's attorney needs to make sure there's a list of people that have to be notified. So the proposed ward's spouse, if they have one, children, if they have any, all of them, siblings, if they have any, parents, if they have any, power of attorney agents, as well as the director if they are residing at a residential facility. So there is a statutory list of people that do have to be notified. And the goal of that is I can't apply to be guardian of somebody's person or estate if I'm maybe a bad actor or the wrong person. So I'm required to tell all these other people that might be able to say, well, this is not the right person to serve as guardian. So that's kind of inviting them to come and say whether I'm the right person or not. So if they feel that I'm not, they have the ability to come contest that. As the applicant, I have to go through an online training and registration that's provided from the state. I also have to go through a background check. So as guardian, you are essentially conflicted out if you owe the ward money, and then if you have some sort of criminal history, depends on what it is. But typically there are requirements for the applicant themselves to meet to be able to serve in that capacity.
All right. So I'm in court. I'm going eyeball to eyeball with the judge. We have very nice judges. We have our hearing. We're asked all the questions you would expect to be asked, right? Like, who are you? Why are you related to this case? They'll ask questions, though, saying, hey, what does the ward own? What does the ward need help with? And when you start listing assets and things like that, is there some kind of financial obligations or bonds that need to be made? How's that?
Yeah. So what the court will do, so let's assume that all goes well, you're appointed as the guardian of the person in the estate. The court is asking for assets and income of the ward because they're going to set a bond that's appropriate for the amount of cash. A bond is just a form of insurance so that if I, as a guardian, were a bad actor, I had access to the annual income as well as the available cash of that ward, I'm going to need to get a bond big enough to cover that amount. So if the ward has annual income of $60,000 and has $40,000 in the bank, well, what I have available before I have to come back to court is $100,000. I will probably have to get a $100,000 corporate surety bond. That's insurance. It probably costs $300 for the premium, so don't let that scare you. But it is part of the process, right? And it's a very important safeguard that the court is putting in place. If they are allowing me to serve as guardian and to have 100% control of someone's finances, there needs to be a safeguard that I'm not going to do something inappropriate with that.
And of course, as part of those safeguards, once we're appointed, once we have our actual letters of guardianship, which is the key to getting things done, the process doesn't just end. You don't walk away from it, and the court doesn't have any more oversight.
Right.
There's certain expenditures that you have to ask for court permission to do. There's certain actions that you'll need permission from the court to do, because ultimately the court is running the guardianship. And then after a year, I have to submit all sorts of documents, not necessarily tons, but a sufficient amount of information like bank records and such to show that X amount came in and it was spent on the way it was supposed to be. The courts are not going to want a bad actor who's misusing those funds to stay as a guardian.
Right. Within 90 days of appointment, you have to file an inventory that lists all of the ward's assets. You also have to file an application for annual expenses. It's basically a budget that says, here's what I'm going to spend for the year. At the end of the year, you file an annual report as the guardian of the person and an annual accounting as guardian of the estate. And the court asks you to provide bank statements, receipts, cancel checks. You have to prove every penny that's been spent out of that estate.
Yep.
It is an expensive process because you're using attorneys throughout this. If you need to sell a home, a car, any property during that time, you have to apply to the court and receive approval for the sale. So when we talk about lesser restrictive alternatives, a guardianship really is a lot of work. Making sure that you are accounting for and documenting everything that you spend during the year can be, even if you're doing the right thing, it's still a lot of paperwork to keep up with. And it's really important because you do have to do it every year until the ward passes away. And then when the ward passes away, you have to file a final report and ask to be discharged. So it's a lot of work you're taking on as the guardian.
And when clients come in, a lot of folks just aren't that familiar with this area of the law. The first thing I hear is, hey, I need a guardianship. I need to be in charge. I need a guardianship for so-and-so. And I usually, say, let's explore that, because it's definitely an option, but it's not necessarily my first option. If I can do the least restrictive, just like the law would prefer, I'm going to try to steer down one of those least restrictive paths. Not always possible. Sometimes it simply is what it is, but not necessarily my first choice.
Yeah, for sure. One question we get a lot is whether two people can be guardians, and the answer is usually no, but you can have co-guardians if they are both the biological parents of the proposed ward or they are a married couple. So you can't have siblings that are guardians together. You have one guardian of the person, one guardian of the estate, so you could split up those duties. It's usually not a great idea to do that, but you could. So you usually will end up with just one guardian. If something happens to that guardian, you can apply to the court to appoint a successor guardian, and that process is much, much smoother than the original application.
Yeah.
Because they're just proving up that they're able to serve, they're qualified themselves and going through that process. So it's not really been a hardship that I've seen to have only one guardian appointed, and I think that helps make it clear who's actually making the decisions there.
Yeah.
What if I were to become guardian and I did have letters of guardianship? Give me some examples of things that I might do with those. Like, what if we had clients need those for in the past? What would that help somebody with?
Yeah, so the situations where I see it the most is where I have most of mine are going to be elderly adults who are wandering, leaving their house, not making good decisions. Situations where they're driving when they shouldn't be. So my guardians will be taking the keys, taking away that driver's license because they no longer have a ability to drive. We'll be doing it for placement. Like, I need you to stay in a secured facility because you've been wandering in a dangerous manner. So sometimes that means lockdown facilities. Sometimes that just simply means a long-term care nursing home. Sometimes it means less restrictive means, but I have had situations where someone's physically in danger and we are forced to do a guardianship. And that's obviously the worst case scenario, but that's the one that scares me the most, where dad's just disappearing and being found, doesn't know how he got there. In those situations, we are doing residential placement. And using those powers of attorney, they'll be going to the facility, they'll be talking to the facility, say, hey, I'm in charge, there's a guardianship, and I am placing dad here, and this is where dad needs to stay.
Yeah.
That's the most severe I see.
Yeah, I would say, right, yeah, a failure to provide your own medical needs and making bad decisions medically, or the introduction of a bad actor is kind of where you see those most of the time. So that if a parent is unwilling to provide their own medical care or make the good decisions for what they need or where they need to be, or you have a bad actor who comes and frequently takes advantage of that person. Those are probably the most common for me.
Basically, a thief is showing up and robbing your parents or your loved ones, taking advantage of their mental capacity, removing their benefits for their own personal use. That's true. Chasing off the ne'er-do-wells is the other way we use that guardianship. Go down to the bank, lock up the accounts, move it to a guardianship account, and then have the dollars accounted for.
Right, because what can happen is even if you have a power of attorney for mom, they can come get mom to sign a new power of attorney, take her down to the bank, get at it on the bank account. So as long as mom is making her own decisions, if she's vulnerable to making bad ones, someone can pretty easily take advantage of her and make changes to a plan that might otherwise have worked just fine. But the introduction of somebody who's trying to fraudulently take from mom is problematic.
Well, what about timing? Because guardianship is a process. It's a process. There might be different forms of it here, but I mean, is this something you just snap your fingers and say, wow, dad has a problem, tomorrow we have a guardianship? How does that work?
Yeah, no, it does require some planning. So I would say here in Gray County, guardianship probably takes at least 60 days to get through and can certainly be longer. What we talked about so far is permanent guardianship. There is a temporary or emergency guardianship, but even that still probably takes at least 2 weeks. So there are some, if you are in an emergency situation, but it is still not going to be a tomorrow type thing. One thing I do want to talk about is the intersection of mental health and behavioral health needs and the guardianship. So if someone is a danger to themselves or to others, the emergency process is going to be through an involuntary commitment, which is going to be probably either because the person went to the hospital or the police were called and that person detained them and went through that process. If someone is involuntarily committed, it's probably for a period of 14 days or less, but a lot of times guardianships end up happening around that time, and it wouldn't be something you could really do in advance, but the guardianship can then step in and allow someone to decide, medication as well as placement. However, guardianships are really not designed to address mental health. They're the only tool that there really is legally, but they're really not designed for it. So even if I am the guardian, my order needs to specifically say that I can okay psychiatric medicine. Otherwise, I don't have the authority to do it. And even still, I cannot check someone into a behavioral hospital. So if you are the guardian and you're the guardian due to some mental health issues, it will help, but it will not 100% solve that problem for you because that person either will still have to be involuntarily committed or check themselves in as the guardian. You still don't have the right to check somebody into a behavioral hospital.
Certainly an imperfect tool
Right.
That a lot of clients have to use.
Yeah, sometimes you don't have a choice. Yeah, sometimes it's still the only way that you're going to get the information and you're going to get to decide medicine and placement after they leave the behavioral hospital. So,
and frankly, in Texas, there's nothing more. I mean, this is as far as you can go is a guardianship. There's no greater tool. So if it is the biggest hammer, sometimes you just use it, even if it isn't quite the right tool for the job.
Right. I do try to be super honest with folks about what a guardianship provides, though. So if my aging parent is just very difficult, and sometimes that happens, right? And it's, maybe not their personality originally, but due to a diagnosis of something, that is just how it's manifested. Being guardian can give you the ability to decide where that person lives. Well, if mom, routinely hits staff or throws chairs through windows or does other things, it doesn't give you the ability to make the placement keep mom. Yep. Or if you've hired in-home help and, mom yells at people or spits on people, having a letter of guardianship that says you are the guardian does not change mom's behavior. It does hopefully allow you to bring resources in, but it is still going to be very, very hard. That is a burden that you would be taking on to make those decisions and provide that care, and it doesn't solve all the problems. If mom needs to take a pill, but she physically refuses, the letter of guardianship is a piece of paper. Right. Mom needs to go to the doctor, but she physically declines to get in the car. Yeah. I mean, there are, legal solutions you can work on with the doctor, but just it is not a perfect, this is going to solve all my problems type of thing. The problem exists. Yep. This is a tool that will hopefully help you manage it, but is not going to solve all the problems.
Third parties are sometimes leery. I mean, yes, you have a letter of guardianship, but they don't necessarily understand what that means. They're not always willing to I don't say lay hands on. They're not always willing to guide your aged parent into the right building or right car. I've had times before where I've been disappointed in third parties because they're just afraid or don't understand. So sometimes as a guardian, not only are you becoming educated in the system, you have to educate those third parties that you are relying upon to take care of your parent because you can't always be with them 24/7.
Yeah.
So
Yeah, absolutely. So it can be a powerful tool, but only in the right situations and certainly not something to jump to as a first option. Yeah. Anything else you want to say about guardianships?
that's all I got.
Okay, super. Well, thanks for joining us today, guys. We'll see you next time.